carefully to the evidence and the arguments of counsel. Now I ask of you the same careful attention to the law as determined by the court, which you must apply to the facts as you find them from the evidence. You alone, as jurors, sworn to try this case, must pass on the issues of fact, and your verdict must be based solely on the evidence or lack of evidence and the law as it is given to you by the court. The defendant, Henry John King, is charged with the crime of possessing burglarious tools in that on March 13, 1995, in Broward County, state of Florida, he did have in his possession tools designed for cutting through the safe at the First State Bank of Margate Shores. It is a crime for any person to attempt to commit an offense prohibited by law, and in such attempt to do so, any act toward the commission of such offense. The charge of possessing burglarious tools includes a charge of the lesser offense of an attempt to commit that crime. An attempt to commit a crime consists of the formation of an intention to commit that particular crime at the particular time and place, and the doing of some physical act toward which was intended to accomplish the commission of the crime. The act done must be more than mere preparation to commit the crime. The defendant has entered his plea of not guilty. The effect of this plea is to require the state to prove each material allegation of the information beyond and to the exclusion of every reasonable doubt before the defendant may be found guilty. It is to the evidence and to it alone that you are to look for such proof. You must find the defendant guilty beyond and to the exclusion of every reasonable doubt. If you find from the evidence that all of the material allegations of the charge have been proved, then you must find him guilty. To overcome the presumption of innocence of the defendant and to establish his guilt, it is not sufficient to furnish evidence merely tending to prove guilt, nor to prove a mere probability of guilt, but proof of guilt of the defendant beyond and to the exclusion of every reasonable doubt is absolutely necessary. You must carefully, impartially, and conscientiously consider, compare, and weigh all the evidence, and if after doing this you think that your understanding, judgment, and reason are well satisfied and convinced to the extent of having a full, firm, and abiding conviction that the charge has been proved to the exclusion and beyond a reasonable doubt, it is your duty to find the defendant guilty. A doubt, which is a mere possible doubt, a speculative, imaginary, or forced doubt, is not a reasonable doubt, and for the reason that everything relating to human affairs is open to doubt. This great doubt, such as must influence the jury to return a verdict of not guilty where they have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all of the evidence, there is not an abiding conviction of guilt, if having a conviction, it is one which is not as stable a one, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubts are reasonable. It is the evidence introduced upon that trial, and to it alone, that you are to look for such proof. A doubt which is not suggested by or does not arise from the evidence is not a reasonable doubt and should never be considered. In other words, you have no right to go outside the evidence for doubts of any kind. However, a lack of evidence or an insufficiency of evidence may create a reasonable doubt. You are the sole judges of the weight and sufficiency of the evidence and of the credibility of the witnesses. You should reconcile any conflict you find in the evidence without imputing untruthfulness to any witness. If you cannot reconcile any conflicts you find, then it is your duty to reject the evidence you find to be unworthy.